The House will come to order. Today, the Pledge of Allegiance will be led by Audrey Skiles and Lyndon Glore from Rooney Ranch Elementary, Lakewood, Colorado. Guests of Representative Rebecca Stewart, House District 30.
Please join us for the pledge.
I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible.
Mr. Schiebel, please call the roll.
Representatives Armagost, Bacon, AML Bacon, Barone, Bird, Basenecker is excused, Bottoms, Bradfield, Bradley, Brooks, Brown, Representative Brown,
Excused.
Caldwell, Camacho, Carter, Clifford, Representative Clifford,
Excused.
DeGraff, Representative DeGraff,
Excused.
Duran, English, Espinoza, Ferre, Representative Ferre,
Excused.
Froelich, Garcia, Garcia Sander, Gilchrist, Gonzalez, Hamrick, Representative Hamrick,
Excused.
Hartsook, Jackson, Johnson, Joseph, Kelty, Leader, Lindsay, Representative Lindsay,
Excused.
Linstead, Rep Linstead,
Excused.
Luck, Lukens, Mabry, Representative Mabry, Mabry is excused.
Excused.
Marshall, Representative Marshall,
Excused.
Martinez, Morrow, McCormick, Pascal, Phillips, Puglisi, Richardson, Ricks,
Present.
Rootnell, Ryden, Sirota, Smith, Soper, Stewart K, Stewart R, Story, Representative Story,
Excused.
Sukla, Taggart, Tatone, Rep Tatone,
Excused.
Valdez A, Representative Valdez,
Excused.
Velasco, Rep Velasco,
Excused.
Weinberg, Wilford, Winter, Woodrow, Representative Woog is excused, Zokai,
Excused.
Zokai is excused, and Madam Speaker.
Here. With 53 present, 12 excused, we do have a quorum. Representative Carter.
Madam Speaker, I move that the Journal of Thursday, February 13th, 2025 be approved as corrected by the Chief Clerk.
Members, you have heard the motion that the journal be approved as corrected by the chief clerk. All those in favor say aye. All those opposed, no. The ayes have it. The motion is adopted. Members, I will invite you to take your seats. We have a very important piece of news to share. Please take your seats, members. Minority Leader Puglisi.
Thank you, Madam Speaker. It is with an incredibly heavy heart that I inform the House that former Representative Rod Bockenfeld passed last night, surrounded by his family, and it was very peaceful. We will be doing a more formal memorial tribute. We didn't have time today to get that together, and I know both the Senate and former representatives and senators would like to be with us too, so I'm coordinating that. Thank you to the Speaker and Majority Leader for your graciousness. And with that, I would ask that we ring the chimes for Representative Bockenfeld. Thank you.
Thank you, Minority Leader Puglisi and members. Our condolences are with Representative Bockenfeld's family and many friends. Madam Majority Leader.
Thank you, Madam Speaker. I move that the following bills be made special orders on February 14th, 2025 at 9:18 a.m. Senate Bill 10, House Bill 1041, House Bill 1114, House Bill 1124, House Bill 1018, House Bill 1093, and House Bill 1086.
Seeing no objection, the bills listed by the Majority Leader will be made special orders on Valentine's Day, February 14th, 2025 at 9:18 a.m. Representative Mabry. Members, you have heard the motion. Seeing no objection, Representative Mabry will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request to have a bill read at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the Majority Leader, and the coat rule is relaxed. Mr. Shibo, please read the title to Senate Bill 10.
Senate Bill 10 by Senators Mullica and Pelton B., also Representative Brown, concerning electronic communications in healthcare.
Representative Brown.
Thank you, Mr. Chair. I move Senate Bill 10. There is no committee report.
To the bill.
Thank you. Senate Bill 10 authorizes the use of electronic communications for all communications, including required notices related to consumer health insurance benefits. This legislation enables common sense reform to allow consumers to leverage familiar internet-based technologies to access, receive, and organize their health benefit plan information and any notices or communications related to their health benefits. It's based on a National Council of Insurance Legislators E-Commerce Model Act, and importantly, it allows for folks to opt in to electronic communications so they can still receive paper at no cost, excuse me, no additional cost. In the Senate, they adopted amendments at the request of the Colorado Division of Insurance to enable consumers to also submit electronic communications to their health plans. So this allows for communications in two directions with health plans. It will help to streamline communications for consumers and for companies, and I ask for an aye vote.
Is there any further discussion on Senate Bill 10? Representative Bradley.
Thank you, Mr. Chair. I just wanted to come up here to talk to my caucus since these bills are coming fast and furious. This is a good bill. Just wanted to let my caucus know. Let me just give you an update since we seem to have to do this on the floor these days. If passed, this bill will require health insurers to utilize electronic communications unless a covered person opts to utilize non-electronic methods of communication and waives any civil liability for insurers for issues or problems with electronic communications. This bill will give Coloradans the choice to receive important insurance documents electronically instead of on paper, as long as these electronic methods meet the standards set by the Uniform Electronics Transactions Act. This means that electronic delivery of insurance information will have the same legal standing as traditional paper delivery. However, insurance companies must still provide paper copies if someone doesn't have reliable internet access, and individuals can choose to receive paper communications if they prefer. So I am a yes on this vote, or on this bill, and just wanted to let my caucus know. Thank you so much.
Any further discussion on Senate Bill 10? Seeing none, the motion before us is the passage of Senate Bill 10. All those in favor say aye. All those opposed say no. Senate Bill 10 passes. Mr. Shebo, please read the title to House Bill 1041.
House Bill 1041 by Representative Smith, also Senators Coleman and Amabile, concerning measures to support a student athlete in the use of their name, image, or likeness.
Hold for the bill sponsor. Yeah, the committee will stand in brief recess. The committee will come to order. Madam Majority Leader.
Thank you, Mr. Chair. I'd like to move House Bill 1041 until after House Bill 1114.
Seeing no objection, House Bill 1041 will be moved until after House Bill 1114. Mr. Shebo, please read the title to House Bill 1114.
House Bill 1114 by Representative Carter, also Senator Gonzalez, concerning allowing the defense to review a tangible object in preparation for a criminal trial.
Representative Carter.
Okay. What is it? So I move House Bill, House Bill 1114. I want to amend the Judiciary Committee report dated February 5th with L005. Okay, they just told me I had to do it the other way. They just told me I had to do it the other way. You have to move the bill and the committee. Okay. Okay.
All right, Representative Carter.
So I move that House Bill 1114 and the committee report.
All right, to the committee report. Representative Carter.
So to the committee report. I move to amend the Judiciary Committee report dated February 5, House Bill 1114, Amendment L005. I move L005. And ask for it to be displayed.
Okay. That is an amendment to the committee report. We'll hold for it to be displayed. Okay, Amendment L5 to the committee report. Is that better? All right. Amendment L5 to the committee report is properly displayed. To the amendment, Representative Carter.
Thank you, Mr. Speaker, or Mr. Chair. This amendment has been made in conjunction with us communicating with the district attorneys as well as the sheriffs. After the original bill was in committee, we continued our stakeholding, and we came up with some additional information regarding the recording, and that was with the both the sheriffs and the district attorneys.
Okay, is there any further discussion on Amendment L5? Seeing none, is there any objection to Amendment L5? Or all those in favor? Sorry, I'm not chairing a committee right now. All those in favor of Amendment L5, please say aye. All those opposed, say no. Amendment L5 is adopted. Representative Carter, to the committee report.
Nothing further.
Is there any further discussion on the committee report? Representative Armagast.
Thank you, Mr. Chair. Right now, the bill as amended does not require law enforcement to record an evidence without, or viewing, by either prosecution or defense. It only says that if the evidence viewing is recorded by law enforcement, it has to be for the purpose of chain of custody, integrity, safety of the evidence, and that law, if law enforcement records an evidence viewing, has to alert the district attorney, who will alert the defense. In turn, alert the defense. I have to.
Hang on, Representative Armagast. Members, it's a little bit too loud. If you could please take your conversations to the sides so that we can hear the discussion happening here in the well. Representative Armagast, to the committee report.
Thank you, Mr. Chair. An object subject to visual recording is the way it's drafted. The bill currently, as it currently stands, not all objects will be visibly recorded while being inspected by either side. Phrasing it the way I think it needs to be phrased just means that if law enforcement makes the choice to record an evidence viewing, any object that is a part of the recorded evidence viewing has to remain entirely within the camera's field of view during the evidence viewing procedure. So with that, I move L4 to House Bill 1114 and ask it, the committee report has to be properly displayed.
Okay, this is an amendment to the committee report. Okay, L4 to the committee report is properly displayed. To the amendment, Representative Armagast.
This just helps kind of clarify, making sure things are in proper view. I think we had some issues in committee that we really spoke on that were in the discussions and arguments of how we can do this that best accommodates everybody without putting any egregious burdens on the law enforcement agency, the defense, or the prosecution. This makes it a little easier for everybody, so I encourage an aye vote.
Representative Soper.
Thank you, Mr. Chair. I also stand up here encouraging an aye vote on this. This was very passionate from one of our colleagues, and he couldn't be here to run the amendment, so I appreciate that it's being run. But this is exactly what we need to have done, because this was really where the bill was originally. This is good policy, and I'd encourage a yes vote.
Any further discussion on Amendment L4? Representative Carter.
Thank you, Mr. Chair. Just to let everyone know, we've been stakeholding this bill since it came out. The amendment, I'm asking for respectfully a no vote on the amendment. I appreciate the representatives who thoughtfully have looked at the bill and decided to bring forth amendments to help move it forward and help with the stakeholding. However, I'm asking for a no vote on this amendment. We've been speaking with both, as I indicated, the sheriffs, the chiefs, and the district attorneys. And so at this point, I'm asking that this portion or the amendment be struck.
All right, is there any further discussion on Amendment L4? Seeing none, the motion before us is the adoption of Amendment L4. All those in favor say aye. All those opposed say no. Amendment L4 fails. To the committee report. Is there any further discussion? Representative Armagost.
Thank you, Mr. Chair. So there's a lot that happened. There were a lot of things that I saw that were good about this and helping solidify what we need for evidence viewing, for the recording, everything to be used by the defense, by the prosecution, and law enforcement presence, or at least an evidence technician presence. But that viewing being as needed. The most accommodating way for the agency. We can't expect agencies that are smaller, less able to accommodate the needs that this bill requires. We've already passed legislation where law enforcement officers have to wear body-worn cameras, so those body-worn cameras should be sufficient. And we discussed this in the committee, but we also, these discussions are still happening. This is something that we've been told they wanted to, not anyone in the sponsorship here, but behind the scenes, people wanted this to get fixed in the Senate. And as we all know, we don't let anything out of this chamber without fixing it before it gets to the Senate. There's no reason to send something that's not quite complete to the Senate. So I move L6 to the committee report and ask it to be properly displayed. Now what?
All right, that's proper motion. That amendment is properly displayed. Representative Armagost, to the amendment.
Thank you, Mr. Chair. So again, this is just something that with the defense and prosecution being able to look at a law enforcement officer's body-worn camera is sufficient for the purposes in this section. It is functional, it is removable, able to be placed in a way that can view an entire area, spot. It doesn't have to be on the body where it's point of view. So this is something that I think should be sufficient for those agencies that don't have other means to record as needed in this bill. So I encourage a yes vote.
Representative Espinoza.
Thank you, Mr. Chair. I encourage a no vote on this amendment. Specifically in the committee, we learned from both the prosecutor and defense that body-worn camera evidence goes into a data system that cannot be protected and therefore will not protect the rights of defendants or their Sixth Amendment rights to ensure that that evidence isn't improperly related to the public. And so, although I appreciate the intent of this, we understand, and the sheriffs have agreed that they can provide other means. We define defense attorneys outside of the body camera obligations, and so we would ask for a no vote on this amendment. Thank you.
Representative Caldwell.
Thank you, Mr. Chair. I rise in support of this amendment. Sorry, my voice is a little gone. Speak up, sorry. But this makes sense. All of our agencies, we already have body cameras for the simple fact that this legislature required it. So they already have it. We don't want to require our agencies to have to purchase more data storage. They already have these in place. So this is a good amendment. Please vote yes on it. And also, I'm Batman.
Representative Armagost.
Thank you, Mr. Chair. I have to respectfully disagree with my colleague on the body cam not being protected. That is something that is protected and used on a regular basis. That is something that has to, law enforcement is currently required to hand that over to the media before an investigation even begins. So this is, in a lot of cases, the most protected form of video, form of storage that we have, and to ask that burden on our agencies to be able to afford another form of video or data storage, it is costly, and it is a cost that we don't need to put on our law enforcement agencies. And again, I encourage a yes vote.
Is there any further discussion? Seeing none, the motion before us is the adoption of Amendment L6 to the committee report. All those in favor say aye. All those opposed say no.
No!
The amendment fails. To the committee report. Is there any further discussion on the committee report? Seeing none, motion before us is the adoption of the committee report to House Bill 1114. All those in favor say aye.
Aye!
All those opposed say no. The committee report is adopted. To the bill, Representative Carter. Is there any further discussion on House Bill 1114? Seeing none, the question before us is the adoption of House Bill 1114. All those in favor say aye.
Aye!
All those opposed say no. House Bill 1114 is adopted. Mr. Schiebel, please read the title to House Bill 1041.
House Bill 1041 by Representative Smith, also Senators Coleman and Amabile, concerning measures to support a student athlete in the use of their name, image, or likeness.
Representative Smith.
Thank you. Mr. Chair of the Cow? I don't know what I call you.
Mr. Chair.
After a 30-year career as a...
Representative Smith, can I ask you to move the, let's see, if there's a committee, the bill and the committee report.
I move House Bill 1041 and the committee report.
Okay, to the committee report. Representative Smith. Just describe what happened in the committee.
Colleagues, we had a robust discussion about this bill. I laid it over to do more stakeholding and had a couple of amendments. And one was related to high school athletes. They were worried that this bill would pertain to them, and so we made sure that it was very specific. High school students were not included. The other thing that was included in that was regarding what would be protected in a student athlete's contract for name, image, and likeness. So under FERPA, we've got protection of name, date, email, telephone number, social security number, bank account, and so forth. And we have asked to include the financial information for the contract.
Members, it is again too loud. We can't really hear the debate that's happening here in the well. If you could please keep it down or take your conversations to the side. Thank you. Representative Smith, to the committee report.
Thank you very much. I was not specific enough in the bill what exactly financial information was. I then asked to step aside and work with my bill drafter to write an amendment that specifically spelled it out as the fee that would be paid in the contract for using an athlete's name, image, and likeness. That amendment was voted on unanimously. Then we voted on the amendment that was amended, and it passed 9-10-3, I believe. And then the second amendment was related to reporting requirements that CU would do, going above and beyond what the NCAA will require, which is the full amount of NIL money being paid, the amount being paid by each sport program, and the amount paid by gender. And that one also passed 13-0, and then the bill itself passed 9-4.
Okay, is there any further discussion on the committee report? Amel Bacon.
So, Mr. Chair, I'm going to, I just want to give a heads up for procedure, what I'm going to do. I'm going to move amendments so we can see them, but then I will withdraw them.
Okay.
Is that okay?
Yes.
All right. So, members, for those of us that are watching, I know CU's listening, and we've had some conversations also across the aisle. House Bill 1041 is a bill that is very important to our university systems. It's very important to our student athletes. And for those of you who may not know about it, I ask that you hear about this bill. Over the last couple of years, the NCAA has been engaged in lawsuits from athletes. where the athletes are stating that university systems, primarily NCAA, has had kind of like a monopoly on dollars coming in. At the end of the day, student athletes have won the right to receive compensation for their use of their name, their image, or their likeness. And so after years of legal work, it has been held, and I'm sorry to talk about this because the bill sponsor will talk about it, but it's relevant to these amendments. It has been held that students deserve to be paid for that, and so we have to pass a law that allows universities to engage in contracting. Now, the issue is that universities are public institutions. Their sports programs are typically run through auxiliaries or what we call enterprises. And currently, law says that contracts made, the overwhelming majority of them with a few, I think there's a few exceptions, have to be run through public processes, through procurement, and that the contracts have to be made public. Part of what this bill is asking for is that we seal student-athlete agreements on what they will be paid. So I wanted to run in committee. I mentioned 2 issues. I also mentioned 2 issues as to why I did not vote in support of the bill. My opposition is not against the provision in which universities should be allowed to engage, changing the law to allow universities to engage in negotiating, but the issue is around removing contracts from Cora, which means nobody will see not just the students' names, but nobody will see how much they are getting paid. And so I had a few issues with that I want to raise here simply to lay a record, because there was opposition to this bill about carving out these contracts from Cora. And so with that, Mr. Chair, I move L12 and ask that it be displayed.
Okay, that is displayed to the amendment. AML Bacon.
Okay, what L12 proposes was one of my first proposals. I asked, if you look at line 12, if this section of sealing or carving out contracts from Cora, if this section could be repealed in 2 years, in 2027. And the reason why I asked for that is because I believe the law around this will likely change over the next couple of years. I do think there will be questions on, are the students going to be considered employees? We're going to have to see where Title IX goes. Actually, this week, the president wrote an executive order exempting name, image, and likeness from Title IX. So I said, can we start with this for 2 years and then 2 years re-examine it and figure out if we need to write a new law? The first paragraph starting on line 7 also suggests that universities poll and survey their students to see how they are responding to the contracts, to see if they feel like they are earning fair remuneration, or to see how they can engage in contract negotiations. And so that was my first idea or question. The people who are supporting this bill saw this. We've had these conversations. They do not want to see this amendment brought forward. But I wanted to lay, again, the concern is completely carving out these contracts from Cora, where every other contract is not. We know how much the coach is making. We know how much the vendors are making. But we don't know this. And I'll go into reasons why when I show you the other amendments. So, Mr. Chair, I'd like to withdraw L12.
Okay, Amendment L12 has been withdrawn. AML Bacon.
Thank you. Mr. Chair, I move L11 and ask that it be displayed.
L11 is displayed. AML Bacon.
Thank you. Members, what L11 does is it was another proposal. What I also asked is that could we, if the contracts are going to be sealed, could they be sealed for at least 2 recruitment cycles or 2 academic years, which means after 2 years, could they be made public with personally identifiable information redacted? So what would be left is, can we see the contract and the amount of the contract, but no information on the student? And so the first paragraph starting on line 3 talks about 2 school years concerning a student athlete's contract. Starting on line 10, if they grant it, they have to redact personally identifiable information. And starting on line 21, it defines what personally identifiable information is. The reason why we're talking about this in the committee report is because there was an amendment made in committee that defined personally identifying information, not just like your name, your address, social security number, but they also included in the bill financial information, which means the amounts. And so what I proposed is that the contracts be sealed for 2 years, and then they're opened where we can see the amounts. And in talking, again, with the stakeholders or the proponents of the bill, that was not something that they're willing to do at this time. And again, the purpose is to promote some sort of transparency around the amount of money being spent. And so with that, this is what we want to share about transparency. The people who have pushed for this, for the transparency, are reporters, folks who believe the openness helps keep us accountable. I am also the sponsor of the Equal Pay Bill. And what we know is if people do not know what people are being paid, it's hard for them to negotiate. And so while we're talking about we need to do this for students, I also believe that students need to have some transparency so they know how to enter the bargaining as well. At the end of the day, we know that there are other people who are negotiating for pay, including the coaching staff. But when they enter negotiations, they know how other people are paid to give themselves the best advantage. The other thing is, in Colorado, because we may differ from other states, because you will hear what other states are doing, and it is true that other states are trying to exempt these contracts. But in Colorado, we have a culture of transparency. In Colorado, some people believe transparency is to keep an eye on what's happening with public spending so that we don't overspend, and some people care about transparency to ensure fairness. If you don't know what people are willing to pay certain groups, it is really hard to get equally paid. Every lawsuit that have happened at public institutions over equal pay has had to start with people finding out they're not getting paid the same and fairly through other means because it's not public. And so while other states have these laws to exempt contracts, as much as I love my home area of the country, I'm not in a rush to be like Alabama. Hey, go Tigers. And 3 people get that, okay? But part of the conversation does lie here in Colorado because this is becoming a thing that different states are legislating for, and they lie with the states because there isn't federal legislation. In Colorado, we want to be sure that our athletes are protected, but we also want to be sure they have a fair shot, and we also want to be sure that we know how money is going out of the door. So the last thing I will say is, sports and where this money will come through is through a university's auxiliaries. Those are the enterprises. And right now, their governing boards do not necessarily govern them, which means there is no public information, there is no one who is publicly elected who can be held accountable for this information. The only people who might actually know what's in these contracts are the athletic teams, not the public. And while we love these sports, there will be a time where we're going to ask, how much are they getting paid? And that's what this is about. So with that, Mr. Chair, I withdraw L11.
Amendment L11 is withdrawn. Is there any further discussion on the committee report? Seeing none, the motion before us is the adoption of the committee report to House Bill 1041. All those in favor say aye. All those opposed say no. The committee report is adopted. To the bill, Representative Smith.
Thank you, Mr. Chair, and thank you, AML Bacon. We've had a lot of discussions, and I think it's really worthwhile. Colleagues, today I am pleased to bring forward HB 25-1041, Student Athlete Name, Image, and Likeness. This bill will allow an institution of higher education or athletic association to compensate a student athlete for the use of a student's athlete's name, image, or likeness, NIL. As AML Bacon pointed out, we need to do this because we have a settlement that will be finalized in April, and we will have to begin paying our students directly at CU and CSU. Ensuring Colorado law complies with the upcoming NCAA rules is essential for institutional participation and competitiveness. Many other states have already updated their NIL laws to match the impending NCAA changes. Colorado must follow suit to remain competitive nationally. After a thorough discussion with the Education Committee members and stakeholders regarding transparency, we introduced several amendments, which I spoke to at the Committee of the Whole report. The ultimate goal of this bill is to support and protect students, both in making sure Colorado athletes can be competitive nationally and their personally identifiable information remains protected. Thank you.
Is there any further discussion on House Bill 1041? Representative Soper.
Thank you, Mr. Chair. I come down here to speak in favor of this bill. I want to tell you a brief story as to why. Imagine watching your kids play a video game and realizing that on the video game, it's basketball players going back and forth. As you start to see how one player looks, runs, the name on the jersey, the characteristics about that player, you realize that was you. I'm describing the Ed O'Bannon case, the first case that kicked off the change in law that went up to the United States Supreme Court. And Ed O'Bannon was the star player at UCLA. He was drafted into the NBA, played for the Lakers briefly, had a major Achilles injury that ended his professional career. But he was such a famous college athlete that UCLA continued to profit from his name, image, and likeness years after he left college sports. And he never once consented to that in any sort of contract. That kicked off a lawsuit. Many other lawsuits followed, and rules changed with the NCAA. They finally accepted the fact that really colleges and universities should not be profiting on famous students' name, image, or likeness without fair compensation. And that's exactly what this bill does. I do want to say that I know some people might be shocked with the idea that a student could be paid for their name, image, or likeness. But what I will say is, if a school is able to sell a t-shirt with a student's face on it, and you're willing to pay $100 for that shirt, it's not because the school logo was on it. It's because the student's face was on it and they've become famous. They're actually professional athletes, but still in college. America has done a really good job of making professional athletes of really college athletes. We could go to other countries like the United Kingdom, and certainly student athletes never would rise to that fame. After all, you would probably be buying t-shirts with my face on it. I was a college fencer in Edinburgh, but certainly not that famous. So that's exactly why we need this bill, and I fully support this bill. It keeps Colorado competitive and ensures that we can have top students coming to our state. Thank you.
Representative Caldwell.
Thank you, Mr. Chair. I'm not going to spend too long up here because of my voice, but I want to make sure that I agree with all the points that were made by the bill sponsor. So I'm up here in support of the bill, and I just want to highlight the bill sponsor's bipartisanship on this bill. As she had mentioned, when this bill first came to Education Committee, there were issues with it, some very serious issues, and we had to lay it over. And I want to commend the bill sponsor for coming to everyone on the committee, including across the aisle, and saying, what are your concerns about this bill? How can we get you to a yes? And so we laid out some issues. We laid out parental rights and transparency were the two big things. And I can attest that the bill sponsor came to me with the parental rights concern and said, what would you like to see done? And after we laid out what we were concerned about, she came back very quickly with an amendment. And even that amendment needed a little bit touching up, and then came back again with exactly what we asked for. And that part covered the parental rights issue for myself. And the last thing is transparency. There were some issues with transparency. Again, everything that I requested to see in the bill and in an amendment to get to a yes was met. So everything else, I think they summarized the bill well, but I just want to make that point that I appreciate the bipartisanship, and so I'll be a yes. Thank you.
Rep. Bradfield.
Thank you, Mr. Chair. I too am here in support of this bill. When I first heard it, I went, no, nope, 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 nope. But I do want to thank the bill sponsor for being reasonable and understanding that what our concerns were with parental rights, the transparency, the report breakdown, protections for students, and all of those things that you amended and to our satisfaction, and I appreciate that. I do feel very strongly that Colorado needs to make this our own and not always follow every other state, and this is what we're doing at this opportunity. So I urge an aye vote on this bill. Thank you.
Is there any further discussion? AML Winter.
Thank you very much, Mr. Chair, and thank you, Rep, for bringing this bill. If you all haven't gotten a chance, you should get on Amazon. They actually did a documentary about this. LSU was one of the first schools to really dive into this, and it was unbelievable how this opportunity was able to change their lives, and I'm always for things like that. The landscape of the NCAA has changed in wake of the NCAA settlement. We will be at a competitive disadvantage if we do not allow this mechanism for institutions of higher ed to compensate students directly. There were significant amendments in House Ed to address issues, including an explicit requirement that parents be in the room with minors when deals are being negotiated, and the submission of data on the overall amount institutions are spending to Department of Higher Ed, including breakdowns by sport and by gender. And I think that these were really good concessions that were made that I think made everybody good with this bill. I would hope so. So as we move forward and college sports change, I think this is a really good bill, and I think that it's good that our students in Colorado will be able to take advantage of this as well. And I like the bill as is because I think if we dive into too much of the information, there's some safety concerns, competitiveness concerns. So I really appreciate the spirit of the bill, and I will be a yes. Thank you.
Is there any further discussion? Representative Hartsook.
Good morning, and thank you, Mr. Chair. This was a very interesting bill, and I want to thank the sponsors. We had a lot of discussion about this in committee. Usually in our chamber, we're always looking for bipartisan support, and we get that. And we also sometimes we have bipartisan opposition, and that's what we had in this particular case. I do want to commend the sponsors for, some of the amendments that she mentioned were specific things that I brought to her attention. I'm very grateful that she took those to heart and brought those amendments, and for that I'm grateful. I am still opposed to this bill for just the very simple reason that we have seen across the nation, and hopefully CU and none of the other universities get mad at me, but we've had problems across universities when it comes to this kind of money and corruption. We've seen where coaches and other players. There's been money that's been spent that the public doesn't know about. When you're dealing with a public institution, everything should be available, whether it's disclosed or not, but it should be available to be disclosed. And the public does have a right to know how not only public funds are spent, but institutions that they are supporting in the public realm are dealing with money. Do I think athletes should be paid? That would be a different discussion, but in this case, the courts have ruled, so they are entitled to that amount of money. And my position is that the public should also be entitled to know what is being spent upon whom. And that is why ultimately I came down in opposition to this bill, and that's where I still stand. But I wanted to get up here and acknowledge, because I think the sponsor did a tremendous job in accommodating our initial concerns and going through that, and I want to state on the record that I thank her for all of that. So thank you.
Is there any further discussion? Seeing none, the motion before us is the adoption of House Bill 1041. All those in favor say aye. Aye. All opposed say no. No. The bill passes. Mr. Schiebel, please read the title to House Bill 1124.
House Bill 1124 by Representative Ryden, also Senator Michelson Janae, concerning updates to the universal contracting provision requirements for the delivery of behavioral health safety net services.
Representative Ryden, to the bill.
Thank you, Mr. Chair. I move House Bill 1124.
To the bill.
Thank you. House Bill 22-1278, it established the BHA, the Behavioral Health Administration, and it put forth the way contracts with behavioral and mental health providers should be done. Now, it's been 3 years since that's inception. They've done a lot of stakeholding work with a lot of those providers and realized that there's a lot of duplication in the way that statute was written. So this legislation, House Bill 1124, it works to remove some of the duplication, though they are elsewhere in the statute. It's also going to help reduce the burden of providers just by streamlining the contract provisions. We're moving from 16 down to 4. And then thirdly, it's going to really help improve the data collection. We want to collect data to improve health outcomes, not just for the sake of collecting data, and it's going to help with that. And then fourth, I think consumers are going to get more consistent care and consistent access if we have consistent contracting provisions.
Any further discussion? Seeing none, the motion before us is the adoption of House Bill 1124. All those in favor say aye. Aye. All those opposed say no. House Bill 1124 is adopted. Mr. Schiebel, please read the title to House Bill 1018.
House Bill 1018 by Representative Ryden, concerning access to the Department of Labor and Employment's vocational rehabilitation services.
Representative Ryden, a double header here.
Yes. I move House Bill 1018.
To the bill.
You go first. You choose. Representative Ryden.
Thank you, Mr. Chair. House Bill 1018, it works to remove a burdensome requirement that we have in statute for those seeking disability services. So the Division of Vocational Rehab, it's a federal program that we implement here in the state. Representative Gilchrist.
Thank you, Representative Gilchrist. Thank you, Mr. Chair. Thank you, Rep. Ryden. It's an honor to be working on this bill with you. Coloradans with disabilities deserve equitable access to vocational rehab services, ensuring that they can contribute to the workforce and Colorado's economy in a meaningful way. Right now, Coloradans are eligible for these services. Coloradans who are eligible for these services must complete a financial need analysis to demonstrate financial need in order to access some of these services. This requirement can deter eligible individuals from accessing essential services, hindering their employment success. This bill would eliminate that requirement for individuals to demonstrate financial need to contribute to the cost of their services. By taking away this barrier, we will increase access to vocational rehab services for Coloradans with disabilities. It will enhance employment opportunities, leading to greater economic independence and streamline administrative processes, allowing DVR counselors to focus on service delivery. During the hearing, I was deeply moved by the individuals with disabilities who testified about the importance of having a job and how this program enabled them to do this.
They talked about how participating in the workforce gave them confidence and economic independence, like a job does for any of us. I have 2 daughters with disabilities, and although they're too young to utilize these services, I would hope they would be able to when they're older and benefit from this tremendous program. I urge a yes vote.
And I'd like to move Amendment L003 to the bill and ask that it be properly displayed. The amendment that we're bringing today actually came out of committee.
One second, Representative Ryden. The amendment has been properly displayed to the amendment. Representative Ryden.
This amendment is a compromise that came out of a committee. There were several concerns that if we move the financial eligibility requirement in state statute, which actually, we were actually going to keep it as an option for the state still to include. But if we move it all together, that there might be folks, we might be flooded with people utilizing these services from the federal government. So one suggestion was to have a reporting mechanism put into place. So this amendment outlines that. There will be a SMART Act hearing, or it will be included in the SMART Act hearing with the criteria that some of the folks were concerned about, and that will help. It will be over a 2-year period, so it can reflect, hey, is there more people utilizing these services? It will also give an accurate depiction in the SMART Act hearing, of people coming in from the state. That was a concern of one of my colleagues over here, and how many people are exiting the state who are using these federal dollars. And it will also give an overall picture of how much money local, state, and federal goes into this department. And again, that was a compromise based on the concerns from some of our colleagues over here, and we appreciate that. I think it's always great to have data collection, and it gives us more information as legislators when we're talking about, when we're evaluating programs.
Is there any, Representative Armagost?
Thank you, Madam Chair. So this amendment was something in compromises. We were trying to find a way in committee to make this a bill that moves forward with some level of guardrails. There's really no way with the department as it is to regulate or report anything, to sunset anything. As the slight provision, it would have to be a grand sunset, and to create any kind of reporting would obviously create a fiscal note, and that's not what we're trying to do, especially in our fiscal situation this year. So this was one of those compromises we came up to set some sort of guardrails so we could have some mechanism of reporting so that we're not opening something that can easily get out of our control and create a huge expenditure in fiscal years to come. So I would encourage a yes on this amendment.
Is there any further discussion on Amendment L002? Seeing none, the question before us is the adoption of Amendment L002. All those in favor say aye. Aye. All those opposed say nay. Amendment L002 passes. To the bill. Who's gonna, which one? Representative Gilchrist.
Thank you, Madam Chair. We urge a yes vote on this bill today. We're really excited about the opportunity for this program to serve more Coloradans with disabilities. And as I said, with 2 kids with disabilities, I hope they can utilize this program to get a job and maintain that job and feel a sense of worth and contribution to society. So really appreciate the stakeholding and the discussions that we've had, and looking forward to a yes vote.
Is there any further discussions on House Bill 2510-18? Seeing none, the question before us is the passage of House Bill 2510-18. All those in favor say aye. Aye. All those opposed, nay. House Bill 2510-18 passes. Yay. Mr. Shebel, please read the title of House Bill 2510-93.
House Bill 1093 by Representative Stewart R. concerning limitations on local land use policies that impose conditions that limit growth.
Representative Stewart.
Thank you, Madam Chair. I move House Bill 1093 and the committee report.
To the committee report.
Thank you. We added a strike below amendment in the committee report to really clean up some definitions of what we were trying to do in the bill. We removed the section on fee in lieu and parks and open space land dedication. We added a really important piece that allowed municipalities and jurisdictions to ask for a legal review on any land use ordinances that come in front of them to ensure that they don't directly conflict with the Constitution or with these pieces of statute that are now in law. And we really narrowed the focus of the bill to any of the new language to be census urban areas as defined by the United States Census Bureau, to really target what we're seeing in municipalities around downzoning and land use, and really trying to create these guardrails for urban areas specifically. And I would urge an aye vote on the committee report.
Representative Barron.
Thank you, Madam Chair. I also jumped on, I requested to jump on this bill as a co-prime right after I heard it in committee. With the strike below amendment, it made it better for me, and it made it good. So I also urge an aye vote.
Is there any further discussion on Representative Richardson?
Thank you, Madam Chair. I do have an amendment, L003. I'd ask that it be properly displayed. Oh, I move L003 and ask that it be properly displayed.
Amendment L003 has been properly displayed to the amendment.
Thank you, ma'am. So, colleagues, I think this actually is a good bill. It was concerning to me prior to the strike below, but I believe the strike below really gets at the problem that was trying to be solved. I have one small change that I would like to propose, and my understanding of the impetus behind 251093 was the outcome of a citizen petition within a municipality, which spawned some lawsuits and language last year that was adopted that limits numerical caps on growth. This further refines it, and I think it's good. And while I support the thrust of the policy presented by the sponsor and co-sponsor, and limiting this to just the urban census tracts, I think we have the opportunity today to perfect this and make it focus on the specific problem that was trying to be resolved. I think we should further limit the bill to urban census tracts within municipalities. This is a bill that, it's a land use bill. There's very few people in the room, very odd for a land use bill, but it does impact individual property rights, local control, and use of agricultural lands. So while most urban census tracts are within municipalities, some are not. Highlands Ranch is a clear example to myself. Section 1 of this strike below requires that local governments that allow downzoning or reductions in density in one area upzone or increase density in another area. That's kind of reasonable in a town. Within a municipality, your limiting factor is the space you have. And the determination of what the highest and best use of the property is generally left to the local government to decide. For counties, it's almost the reverse. We have lots of unincorporated land. Rezones are generally driven by the property owners who want to determine what their highest and best use is. And almost invariably, the rezone within a county unincorporated area is from agriculture to some type of business or residential. So the problem we have here is when you reduce density in an unincorporated area, the only place to increase density is generally going to be agricultural lands. So this bill would be forcing, when a reasonable decision was made perhaps to downsize density, to take some agricultural land. What makes that a little bit more problematic is those agricultural lands sit in the hands of property owners. It's a private property right, and will further compound it with, in my experience, as a county commissioner, until about 5 years ago, we didn't even have land use code that allowed top-down, county-driven or initiated rezones. So there may not even be a mechanism to increase this density if it were to pass. So I do think with this amendment, we get at the problem that was trying to be resolved. We prevent potential unintended consequences. We could always withdraw that restriction at a later date, but let's take care of the problem that was identified now and not potentially increase problems in the future in other areas. So I would like this amendment to be passed. I'd urge it to be passed to protect our agricultural lands within the unincorporated areas of counties, to protect personal property rights, and give a little bit of thought to the local control processes within counties. But
Is there any
thank
further?
you.
Representative Sukla?
Thank you, Madam Chair. As a previous county commissioner and with quite a bit of extensive knowledge about land use issues, I believe that this is a friendly amendment, and I would encourage an aye vote on this amendment. Thank you.
Representative Stewart?
I do want to thank my very friendly colleagues. I really did consider this amendment. However, I do think that given the language that is already in the bill that specifically limits the scope of this new language to census urban areas defined by the United States Census Bureau, I don't believe that agricultural lands will be caught up in this as the bill is written right now. And I do think that an unintended consequence potentially of this amendment would be to, in more urban unincorporated counties, like the one I represent in Jefferson, like unincorporated Adams County, where we see a lot of new urban housing development, that we could have some unintended consequences of additional housing and density pressure being put on the incorporated areas due to this bill not applying to the unincorporated areas of those counties. So I appreciate the amendment. I appreciate the spirit in which it was offered. I do not think it's necessary, and I would urge a no vote on this amendment. Thank you.
Is there any further discussion on Amendment L003? Seeing none, the question before us is the adoption of Amendment L003. All those in favor say aye. All those opposed say no. Amendment L003 is lost. To the bill. To the committee report, sorry. Representative Stewart.
Thank you, Madam Chair. I would urge an aye vote on the committee report.
Representative Barron.
Thank you, Madam Chair. I also urge an aye vote. Thank you.
Is there any further discussion on the committee report? Seeing none, the question before us is the adoption of the Transportation, Housing, and Local Government Committee report. All in favor say aye.
Aye.
All those opposed say no. The committee report is adopted. To the bill. Representative Stewart.
Thank you, Madam Chair. House Bill 1093 prevents urban areas as defined by the U.S. Census from downzoning their total residential capacity below existing levels. It would allow cities to reduce residential development in certain areas if it makes sense for their community, but it would need to be made up for by increasing housing opportunities elsewhere. Additionally, it will allow for legal review process for jurisdictions who are presented with initiatives that reduce or restrict land use in order to determine the constitutionality or legality as it pertains to current state law prior to potential implementation, and I urge an aye vote.
Is there any further discussion on House Bill 251093? Seeing none, the question before us is the adoption of House Bill 251093. All those in favor say yes. All those opposed, nay. House Bill 251093 passes. Mr. Sheba, please read the title, House Bill 251086.
House Bill 1086 by Representatives Barone and Gonzalez, also Senators Pelton B. and Michelson-Janae, concerning the timing of the enactment of the Interstate Compact on Placement of Children.
Representative Barone.
Thank you, Madam Chair. I move HB 251086. Yep.
To the bill?
To the bill.
To the bill.
Thank you. Sorry, this is my first time moving my own bill. So this is basically a timing bill that we are running in accordance to the Interstate Compact that was voted on last year. And that one was, we currently are running on the old Interstate Compact adopted back in 1975. And this new one that was passed last year requires 35 states to be on board with it for them to be able to work the regulations in on this Interstate Compact, which helps the regulations of people that are trying to adopt children inside or outside the state. And the bill that was passed last year had some language that was a little concerning, that the timing of the adoption of this new Interstate Compact. So we changed that language so where it says that we have to wait until all 35 states come on board for the regulation adoption. And right now we are the 18th state that has come on board, so we still need some more to come in. This might take years still for it to come into effect, but this is just a cleanup language.
Representative Gonzalez.
Thank you, Madam Chair. As my colleague said, we were brought this by the Department of Human Services in Weld County. This is just a quick cleanup bill. This is also an opportunity to provide clarification on the language of a bill that was passed last year. There has been some confusion which has caused misinterpretation and very vagueness that has been hard for attorneys and even judges to interpret the current law that we have now. So this is just a meeting to make sure we provide that clarification for our courts, for our attorneys. And this is for the children as well. So we want to make sure that Colorado has a seat at the table when this compact takes effect, which is the purpose of us introducing the bill in the first place last year. So it gives us a voice as a state once we reach the 35 state threshold to make sure we have a voice in shaping the policy nationwide for the interplace of children. So we ask for an aye vote.
Representative Bradley.
Thank you, Madam Chair. It is an honor to serve with you.
And it's an honor to serve with you, my friend.
I don't say that very often, so. I am in favor of this bill. I want to thank the good bill sponsors for bringing it. This has caused so much confusion in this state. I wondered why we brought this bill forward last year when only 17 states were in this compact. We need 35. Thank you for bringing a great idea to stop the confusion in our state. I will be an adamant yes vote, and I hope everyone will support this great bill. Thank you.
Representative Bradfield.
Thank you, Madam Chair. I, too, want to echo what Representative Bradley said. This bill is not a glitzy, glammy bill, but it does make corrections of some necessary errors that have happened over the years. And I urge an aye vote on 1086. Thank you.
Is there any further discussion on House Bill 251086? Seeing none, the question before us is the adoption of House Bill 251086. All those in favor, say aye. All those in favor, say nay. House Bill 1086 passes. Majority Leader Durant.
Thank you, Madam Chair. I move the committee rise and report.
You have, relax. You have heard the motion. Seeing no objection, the committee will rise and report.
The House will come back to order. Mr. Schiebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report as under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bills 1018 as amended, 1041 as amended, 1086, 1093 as amended, 1114 as amended, and 1124 passed on second reading, ordered engrossed and placed on the calendar for third reading and final passage. Senate Bill 10 passed on second reading, ordered revised and placed on the calendar for third reading and final passage.
Representative English. Members, you have heard the motion. There are amendments at the desk. Mr. Schiebel, please read the first Armagost amendment to the Committee of the Whole report, House Bill 1114.
Representative Armagost moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following DeGraff Amendment L4 to House Bill 1114 to show that said amendment passed, that House Bill 1114 is amended passed.
Representative Armagost.
Thank you, Madam Speaker. So again, this is just something that's going to add a little bit of latitude for our law enforcement agencies to use the video recording without audio recording devices that they have available without having anything that's going to put them in a situation where they have to acquire that and pay for that. So this is getting that ability for them to use audio recording of the evidence that they can, that gives them the point of view that they need, and I encourage a yes vote.
Representative Armagost, I do need for you to move the amendment.
Thank you, Madam Speaker. I move the first Armagost amendment to the Committee of the Whole report and ask it to be properly displayed.
Thank you. It is properly displayed. Representative Carter.
Thank you, Madam Speaker. Once again, as I explained before, we have done multiple stakeholding and will continue to do stakeholding, and at this point, I'm asking you vote no on the amendment.
Seeing no further discussion, the motion before us is the adoption of the first Armagost amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ricks, how do you vote?
No.
Representative Ricks votes no. Please close the machine. With 19 aye, 42 no, and 4 excused, the amendment is lost. Mr. Schiebel, please read the second Armagost amendment to the Committee of the Whole report, House Bill 1114.
Representative Armagost moved to amend the part of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Armagost Amendment L6 to House Bill 1114 to show that said amendment passed and that House Bill 1114 is amended passed.
Representative Armagost.
Thank you, Madam Speaker. I'll do it right this time. I move the second Armagost amendment to the Committee of the Whole report and ask that it be properly displayed.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. So, again, we do not need to push things off to the Senate to fix the problems that we have in the House. I think we need to correct the issues before we give it to the Senate. This will help do that, just giving the law enforcement officer the ability to use what we have already prescribed in this legislature for them to have on them at all times is body-worn camera. That is sufficient and should be sufficient. It should be in this section in the Committee of the Whole report and in this bill, so I encourage a yes vote.
Representative Carter.
I'm asking for a no vote for the exact same reason I asked for the last no vote.
Seeing no further discussion, the motion before us is the adoption of the second Armagost amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ricks, how do you vote?
No.
Representative Ricks votes no. Smith. Please close the machine. With 22 aye, 39 no, and 4 excused, the amendment is lost. Mr. Schiebel, please read the Ryden amendment to the Committee of the Whole report for House Bill 1124.
Representative Ryden moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in adopting House Bill 1124 to show that House Bill 1124 was laid over to Tuesday, February 18th, 2025.
Representative Ryden.
Thank you, Madam Speaker. I move the Ryden Amendment to the Committee of the Whole report and ask that it be properly displayed.
It is properly displayed. Please proceed.
An amendment was supposed to be run, that was not, that I'd like to run. So this is to say that House Bill 25-1124 did not pass, but rather was laid over to Tuesday. I ask for a yes vote.
Thank you. Seeing no further discussion, the motion before us is the adoption of the Ryden Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ricks, how do you vote?
No.
Representative Ricks votes no. Please close the machine. With 60 aye, 1 no, and 4 excused, the amendment is adopted. There are no more amendments at the desk. The motion before us is the adoption of the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Ricks, how do you vote?
Yes.
Representative Ricks votes yes. Please close the machine. With 41 aye, 20 no, and 4 excused, the Committee of the Whole report is adopted. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar till Tuesday, February 18th, 2025.
The balance of the, seeing no objection, the balance of the calendar will be laid over until Tuesday, February 18th, 2025. Announcements and introductions. I have a few folks signed up. Excellent. Representative Hartsook and AML Bacon.
Thank you, Madam Speaker. Members, 2 weeks and counting, we're going to have a party here. We're going to be doing some grilling, bring in some potluck, go shopping, as I said before. If you can't grill or can't cook, bring it on in. We're going to be celebrating as we roll into Mardi Gras, but it's just going to be a great Friday here, the last Friday of the month, that we're going to celebrate and have lots of fun because it is our job.
AML Bacon.
I do want to let a certain representative who has family in Alabama know that I expect you to bring some low country food. And I do want to remind you all, this is in spirit of season, so, go ahead and get out your frustrations. If you're not used to hot sauce, we will introduce you to that. Remember, there's only 2 acceptable kinds. So we do hope that you all bring any food. If you can't cook, please don't cook and buy some food. But we hope to have a really great time. So 2 Fridays from now, please join us. Thanks so much.
Thank you.
Wonderful. Can't wait. Reminder, February 28th. Representative Camacho.
Thank you, Madam Speaker. It's a pleasure to serve with you.
It is a pleasure to serve with you.
Friends and colleagues, I'd just like to make a recognition of this 14th day of February. Not only is it Valentine's Day, but it is Denver Day at the Capitol. And as a proud Denver representative, I'd like to say thanks to the City of Denver for bringing breakfast. And if you get a chance, go meet some of our city officials. Appreciate it.
Thank you. Representative Luck.
Thank you, Madam Speaker. It is Friday and it is Valentine's Day, so doubly want to share the love with you all today. Don't forget. Oh boy. Don't forget that you are amazing and loved, worthy, and adored. And I can't wait to see you again, not on Monday, but on Tuesday.
Thank you, Representative. Representative Joseph.
Thank you, Madam Speaker. It is an honor to serve with you.
It is an honor to serve with you.
Thank you, Madam Speaker. I'm requesting a moment of personal privilege.
So granted.
Members, thank you. So this morning when I showed up here, excited to be here, excited to be at work, to be with all of you, one of our colleagues, a legislative staffer, reached out to me this morning while we were on the floor with tears in her eyes about one of my constituents. I wish to bring to your attention the concerning disappearance of Megan Trussell, an 18-year-old freshman film student at the University of Colorado Boulder and a resident of my district. Megan was last seen on Sunday, February 9th, in her residence hall wearing a blue and gray jacket, dark-colored pants, and white platform sneakers. The CU Boulder Police Department, in collaboration with the FBI and other law enforcement agencies, is actively searching for Megan. Megan's family is deeply concerned because that's uncharacteristic of her to go missing and to go without contacting her family. If you have any information regarding Megan's whereabouts, please contact the CU Boulder Police Department at 303-492-6666 and reference case number 2025-0291. Again, please, if you have any information about Megan, reach out, because all of us would be sad if we were without our family members. So we're missing one of our community members, and her name is Megan. Thank you, Madam Speaker.
Thank you. Representative Stewart. I'm sorry.
Thank you, Madam Speaker. Rep. Hartsook and I are here today to announce that when we are all back on Tuesday, the 18th, we will be celebrating SCFD Day in the Capitol. We'll have some special guests singing the national anthem, doing the pledge, and coming to join us in chambers.
Representative Hartsook.
Thank you, Madam Speaker. And for those of you who've never witnessed this, I mean, this is an amazing event. The halls here at the Capitol will be filled. Interesting characters, interesting animals, great foods downstairs. I mean, go through and see things that you probably haven't seen before. Sometimes things move slow in the Capitol, but you'll see some really slow animals moving here too. So really, come out on Tuesday. We've got breakfast. They'll be here for the day. Get your picture taken with everything. It's a lot of fun day. Thank you so kindly.
Thank you. Representative Carter.
Thank you, Madam Speaker. Just to let you guys know, most of you know I'm the board member for Aurora Public Schools. I have some kids in the building from Montview Elementary. They're wandering around on the scavenger hunt. Hopefully I gave to them. So if you guys want to rise and recognize Montview Elementary, some of my kids from my school district.
Madam Majority Leader.
Thank you, Madam Speaker. I would like to make a short announcement, a reminder that our gracious and kind front desk staff, our assignables, we have lunch that is ready now. So please, please, please pick up some lunch right over here to the side. With that, Madam Speaker, I move the House stand in recess until later today.
Enjoy your long weekend. Seeing no objection, the House will stand in recess until later today.